Great evening, everyone, and welcome to Conversations with, a recurrent web series organized by the Trinidad and Tobago chapter of the Internet Society and hosted by yours truly, Kevon Swift, for tonight's episode, alongside my very elegant co-host, Miss Jacqueline Morris, the Vice Chair of ISOC TT. Hi, Jackie.
Hi.
Wonderful. As a quick housekeeping note, please feel free to ask your questions in the chat or at any time during the discussions, and we'll be sure to address them as best as we can. Also, if you'd like to make an intervention directly, please use the raise hand option, and either myself or Jackie will give you the virtual floor when the appropriate time to do so becomes available. For tonight's conversation, we have our specially invited guest, Mrs. Christie-Anne Morris-Alleyne, the Court Executive Administrator of the Judiciary of Trinidad and Tobago. She is an attorney at law, a trained court executive, and a project management professional with over 33 years active court experience in court management, court reform, judicial reform planning, design and implementation in the region. Mrs. Morris-Alleyne is a graduate fellow of the Institute for Court Management of the U.S. National Center for State Courts. She is respected as the foremost expert in case flow management in the Caribbean region and is trained in areas such as automating court systems, public assets issues, and technologies. She has provided advice and conducted training on various reforms to all common law member states of CARICOM. And at present, Master Morris-Alleyne is a member of the Cabinet-appointed Advisory Committee on Digital Transformation. Folks, we have a wonderful heavyweight in our midst, Master Morris-Alleyne. It is a pleasure to have you here amongst us. Great evening to you.
Good evening to you, Kevon. Thank you for having me.
Right, the heavyweight part, I hope that didn't throw you off because
I turned to the side and got your little side-eye.
No, we truly appreciate your presence for what we want to raise here in terms of digital issues for the common man to understand. So let's get straight into this. Master Morris-Alleyne, how did you get into court administration? What was that trajectory like? When you were studying, how did this even become a thought and something to pursue, something that is so relevant to our society?
Well, it actually didn't start when I was studying. As most attorneys going through legal studies, I was preparing myself for a journey and a trajectory in the law. It was actually while adjudicating, first as assistant registrar, deputy registrar, and then sitting there as a master, that my frustration grew. And at one point I realized that I couldn't sit there and do this anymore. I had to fix the system, and I felt very strongly about it. I realized that there was too much non-value added activity, that the processes actually slowed down what was important to the people, which was getting their dispute resolved. And therefore that we needed to really find a way to make the entire thing more efficient and more customer friendly. And for that reason, I started to delve more into the area of court administration and court management. And lo and behold, I think I really sort of found my love in that way, because I do love what I do.
Right. And just by way of information, not meaning to date you or to out you, around what time could you say that there was a mass computerization of the court system and the introduction of these technologies? I believe that you were also instrumental to something called computer-aided transcription, which is a precursor to other technologies being used now. Around what time did any of this happen here in Trinidad and Tobago?
Well, this sort of actually started in about 1986. There was a project in the region, and I was put to head the the Trinidad and Tobago leg, and it was a UWI, USAID Caribbean Justice Improvement Project. And Trinidad and Tobago at that time was seen as not really needing grants, grant money. So therefore, we were actually given very little money compared to the other countries in the region. But nonetheless, working with a couple of really great committees, we did two things. We started and introduced computer-aided transcription into the region, starting with Trinidad and Tobago. And we also laid the groundwork for the computerization of births, deaths, and marriages, and vital statistics registration. And those were the two biggies that we got out of that project. Computer-aided transcription actually started in 1990. I won't forget that because of the fact that while we were training local reporters, and so therefore we had taken people out of the court system to train them, we had to bring in some foreign CAT reporters in order to hold down the courts meanwhile. And we brought them in during curfew. So we were bringing in all of these foreigners to a very strange kind of situation. So I will never forget the year. Other than that, in 1993, we really took the big jump into case management information systems. And we were the first in the region again to bring in and implement a case management information system. We actually brought it in 1992, the end of 1992, and it went live in April 1993. So that was really a big ticket item. And in those days too, when I talk about big ticket, that was a heavyweight, because I remember we started with an AS400, and in those days, an AS400 was a mighty big piece of equipment. Right. And we brought it in and we started.
All right, good. So 92 into 93, live case management info system, and of course that will be the precursor to what we are seeing nowadays in terms of e-filing. We know that the pandemic and all of these things have caused us to be a lot more digital and a lot more remote than before. So the case management system, what are some of the efficiencies that brought compared to how things were done before? Like specifically, we know just increases efficiencies, but on a practical level of case management, what were some of the things that actually affected with let's say times, let's say the actual procedures?
Well, actually, it has to do with managing what you do and what you handle. One of the things that you have to remember about courts, people tend to think that courts are about judges and some space. I've actually had that said to me at pretty high levels at certain times. But that's not what courts are. Courts are really a series of systems, interrelated systems. And each one of those systems has to be managed. And with management comes information management, records management, etc. So what a case management information system did for us initially is that it helped us to manage the information. Courts handle a tremendous amount of information. That's what, when you file, it's not that you're filing a document. It is that you're filing a document that bears information. And therefore, the document management of it is one thing, but the information management is really the key. So when you look, for example, at how information gets to the adjudicator, when you look at how we deal with research, when you look at how a judicial officer, a judge or judicial officer prepares a judgment, it is all about using information. At the same time, of course, at a higher level, if you can pull back to a higher level, we can then start to look at our throughput. We can study certain things. We can look to see whether a land matter takes longer to go through the system than a running down action. We can start to plan our time better. We can start to manage better. And this is what we were able to do. And it's for that reason that, and because we had a case management information system, that we were able in 1998 to start to introduce case flow management. That would not have been possible with a manual, fully paper-based system of information keeping and information management. At the same time, there were certain things happening within the legal fraternity worldwide. You found, for example, that research had moved from, or was starting to move from completely book-based research to engines and tools like Westlaw, LexisNexis, all of those things. And that was a huge difference. So when you tie the various pieces and elements together, you were able to really advance. When you looked at something like computer-aided transcription, and now we have moved from mainly computer-aided transcription to digital voice writing. When you looked at the change that brought, what it actually did was that it made it so much easier for judges and judicial officers to sum up to a jury. It made it easier for them to write a judgment. It made it easier for the Court of Appeal to function. Because prior to that, notes of evidence, everything that was taken in a case was taken down either longhand or by a few palantypists that we had, and then typed longhand. So therefore, you realize what the time frame was like. And here we moved to a system where you had real-time conversion from stenotypy to English, to words on a page, words on a screen.
Good. Just as a reminder to our audience out there, if you have your questions, feel free to put them in the question and answer segment, the question and answer button here within MS Teams, and we will raise them. In the meantime, between myself and Jackie, we'll use our prerogative to ask Master Morris-Alleyne wonderful and pertinent questions. And I have another wonderful and pertinent question before I see Jackie itching to get one in. I'm sorry, Jackie, I'm going to put mine before yours. You mentioned, Master Morris-Alleyne, the efficiencies that were brought with stenography and the whole ecosystem within the court. Could you tell us a bit more about the evolution of court admissibility rules for digital evidence? How has that changed over the years? Because I know from my little understanding in the past, things like CCTV and like they weren't necessarily admissible beforehand. But how is that playing out now? And are we gearing up to the e-court, e-justice big ticket item that we're going to discuss tonight? So court admissibility rules and digital evidence.
Yeah, sure. Sure, Kevin. We're definitely moving fast in that direction. I remember out of the 1990 attempted coup, that it was a super big deal to have consolidated several of the insurance matters and to actually use videos in the courtroom. I mean, it was a massive undertaking and a really big deal. But the point of the matter is now that that the new laws have provided for digital evidence, provided for the use of video evidence, etc. I would like to see us move in a direction in which we take full advantage of it, and which we take it in which as well we take it to the nth. At present, people tend to think about, okay, well, I can use, CCTV and okay, and that's how they see it. But the point of the matter is that the opportunities are endless. One of the things that I am really hoping to see is the much greater use of litigation support technology. And we are building out the courts to provide for the use of litigation support technology. But it means that my colleagues at the bar must provide must provide that kind of evidence. They must think in terms of using video evidence. They must think in terms of using animations. Very important, for example, the use of animations in things like running down actions, etc. They must think in terms of using 3D cameras. There's so many things that can be done. What you find is that we show photographs, we show maps maybe and surveys, but we don't as yet go where we can go.
Right.
So to take us a cheap little borrow of that split infinitive. So we need to sort of boldly go where no man has gone before, right? That's where I would like to see it go. That's my vision.
Niran asks a tack-on question to that. He asks whether they still require video on CD and DVDs within the court system.
Actually, no, we don't. No, I'll just leave it there. No, we do not. Does that mean that some of the people who are bringing video evidence to us still bring it on CDs and DVD? Yes, they do. Which means, of course, that we have to be prepared for the time being to show it in that way. But hopefully, it's a question of moving our customers in a particular direction.
Okay. And I know we started very much on this entirely holistic concept of e-court and e-judiciary. And I know, Jackie, in a previous conversation, we were discussing this at length. So I don't know if, Jackie, you want to put forward something there for Master Morris-Alleyne.
Yeah, actually, I wanted to build on what we were just talking about with the 3D cameras and so on and so forth. And there's a question that says, is it the systems that we have, are they sufficiently media agnostic? Otherwise, as if someone comes in with any sort of evidence in any format, is that is something that we should be thinking about?
Well, it is actually something that we have been thinking about. We're in the process of introducing some new software in the judiciary, and it's called Case Lines, and it's actually evidence management software. It enables us to show from several types of media. So yes, it is agnostic. We're looking for technology neutrality as much as possible and seeking to move forward in that way. Case lines is really quite an exciting endeavor. I think it will make that transition towards using litigation support technology easier. It's quite easy to use. The bench has been playing with it and is getting ready to deal with it. And pretty soon we'll be taking it out to our colleagues at the bar and getting them introduced to it. The places in which it's being used at present, because it's not bespoke, the places in which it's being used at present have had tremendous positive results with it. But we intend to take it even further.
So when you say even further, do we see soon-ish the possibility of having everyone in court put on virtual reality goggles and step through a crime scene that was recorded in 360, in 3D? Do you see that sort of thing happening?
I don't see it happening now because courts are dinosaurs. The legal profession is a profession that is really steeped in tradition. It is a profession that is very slow to move. But there's a difference between, do I think I'm going to see that soon? And can that be done? Yes, it can be done. And to my mind, once it can be done, we need to open our minds to it. You know, it ties in with the entire concept of digital transformation. Huh? Mm-hmm. Because the thing about digital transformation is that it's not about the technology, it's about the people and the processes.
Mm-hmm. Correct.
And a key part of the whole thing is to have people's minds open in a particular way, to stop people thinking in 2 dimensions and move to a third, and beyond.
And maybe even a fourth, because one of the things that you've talked that we know that animation works really well with is for slowing down things so that we start to play with time, so that we can see how something happened.
That's correct.
And also for supporting, I don't know, maybe some of those dry-ish technology, dry-ish scientific expert witness testimonies, because
that's correct.
A picture does paint 1,000 words, and rather than someone sitting down and discussing, say, for whiplash or an accident, which one of the various vertebrae was a thing and where we had to put the pin and so on, and you can just show them.
That's correct.
Is that available in the law right now? Could we do that if someone wanted to?
Yes, most definitely. You can do it if someone wanted to. Have we been seeing it? No. Will we get there soon? I think so. I think we'll get there sooner rather than later. And interestingly, I think that the capabilities presented by something like case lines will help people to get there faster. I also think the fact that we have had to be having virtual hearings and therefore move to a visual kind of scenario will also help ensure that we get there faster.
Right. I wanted to just intervene there and just to expand a bit on what Jackie was mentioning. So we spoke about the evidence management, software, case line, digital voice writing, litigation support tech. What are some of the other highlights or elements of the e-justice concept that we, as let's say, future digitized citizens of the Caribbean, we can look forward to?
Well, you know, let me put it to you this way. we have to look at how the courts function and take things along the way. Let's look at the process. So therefore, you have the filing of matters, the starting of matters. So therefore, with that, yes, we have e-filing. We have also been moving towards more opportunities for what we call pro se litigants, self-represented litigants, and even actually for attorneys, so that we are looking more at things like generated applications. So for example, where people go through a series of questions, and by answering the series of questions, they generate their application. We have actually done a lot of work in it in the area of applications for probate and letters of administration. You know, when someone dies and you have to deal with their will or their estate, there's a particular application process. And so we have done a lot of work on that. And we are pretty much ready to go in terms of those sort of question-driven generated applications. So we're looking forward to testing that very, very soon. Also, we're moving in a particular direction with small claims civil courts. Thus far, we have in Trinidad and Tobago called them petty civil courts. But they deal with cases of a value of 50,000 and under, but they are not heavily used, not to the extent that they should be used. And what our customers have made clear to us is that the system isn't heavily used because the system is too cumbersome. Okay. And therefore, we have to take the cumber out of it. And so we have been involved in an entire project to introduce instead small claims courts, which would include that type of generation of applications, etc., as options. Of course, there are other things in it, such as online dispute resolution, including online mediation, things of that nature. So you have all of those things in terms of the application processes that we're dealing with, and the e-filing processes that we're dealing with. Of course, along with that, once you come to you file something, then you're dealing with your e-records management. And so therefore, we're looking at that as well. And we're heavily involved in improving that aspect as well, too. Then you go through processing. So when you think of processing now, you think of moving information, you think of using information, you think of sharing information, you think of multiple people accessing information from the same source. So right there, I don't have to tell you that you're seeing right there, you're seeing IT and you're seeing digitization as well. In court systems, a lot of signing goes on. And so very important to us has been the entire issue of e-signatures. And toward this end, we have actually, well, the judiciary actually uses e-signatures, and we've been using e-signatures for all of our internal processes, and also for documents that we generate. So therefore, e-signatures for court orders, etc. We have even dealt with e-signatures for people who need to take oaths from us, written oaths. So that entire area is an area that we have worked heavily on, and we are advancing. And with the National Digital Transformation Initiative, I've been involved with a team of people in advancing the whole question of e-signatures across the public service. So we're at the stage where the standards are being set, and pretty soon you'll see the standards generated. You'd see the standards, I wouldn't, not legislated, but the guidelines and moving forward in that direction, hopefully. And what we pray and hope is that the public service, especially those areas which have been very slow to move on the question of e-signatures, then start to make the transitions. And hopefully with good change management, we will see that happening in relatively short shrift. I think when people stop being as nervous about it, I've never quite understood the extent of the nervousness, to be very frank with you, except for the fact that people are rooted in seeing ink on paper.
Yeah.
You know, but as I tell people from time to time, you know, as we discuss this, I say, you know, I'm not a handwriting expert. There's no way I can tell whether that's your signature or somebody else's.
Exactly. Yeah.
You know, so therefore an e-signature is actually far safer, far stronger, much more checkable, and far less open to fraud than a wet signature. So, you know, and sometimes, you know, after they've held on to it and then they sort of stop and think about that, they say, well, you know, yeah, okay, you're right. So, you know, hopefully we will be able to move the public service in that direction. To me, that's extremely important.
So, Master Morris-Alleyne, you have given us such a comprehensive panorama of the e-justice, e-judiciary concept. And I've latched on. I am engrossed with what you were just mentioning about e-signatures. I mean, Jackie and ISOC TT, we will know this, and to know that this is functional, up and running, all of the rational fears are out within the court, the judiciary system.
Or in the court, yes.
And to see that that could be extended throughout the public service, that is really music to my ears. I wanted to just go back on a point.
Wait, let me just ask one quick question there.
Sure.
Now, digital transformation isn't going to get rid of the digital divide entirely. We know this. There are always going to be people who are unable to access for some reason or another. But given that it's our constitutional right to have access to justice, how do we balance that? How do we not leave people behind with access to justice in an e-judiciary?
Well, I'm going to step back on that many years. And I'm going to step back to what I think was one of the most difficult headspace transitions to get made in the judiciary. And that was to move to the concept of customers and service. Judiciaries are authoritative. Judiciaries have power and authority. And they never really had to take into account the customer. They never had to take into account really the inconvenience to people. And therefore, you found that, you know, you would call somebody to jury service and they just had to drop what they're doing and they come to jury service. Well, that still exists, yes. But you call somebody to give evidence, and you call them to give evidence on Tuesday, and they sit all day Tuesday outside waiting, and they never called, and then somebody comes and tells them, well, you know, we didn't get to you, so come back tomorrow. And if they don't come back tomorrow, I mean, with all due respect, you could all sorts of things, you know, you had the power and authority to do. In the 1990s, we started to talk about courts as a service. We started to talk about the people as our customers. And that was the huge sea change. And it was a very difficult change to make because it was contrary to everything that not just courts, but even the legal profession was grounded in. Yeah. If you even understand the history of the common law legal system, the history of barristers and solicitors and what that was, you'll understand, because the history was that barristers were the noblemen, solicitors were the merchants. And so the people dealt with the solicitor, but the barristers never sullied their hands with people. So if you look at the back of a barrister's robe, there's a little hood that is stitched into it to this day out of tradition. And that is because the barristers never discuss money. So the solicitors put the money into the barrister's hood. And so that entire concept, and especially taking into account the fact that a judiciary was really barrister-driven, what it meant was that there was a big disconnect. Now we move to the concept of customers. And I spend that time in saying that because when you deal with the digital divide, you have to think about the people as your customers. And therefore, you have to address the question of customer service. And you have customers who are at various levels of IT capability. How do you provide for them at each level? And those who are at 0 level, what do you do?
Exactly.
And so therefore, what we do at 0 level is that we set up kiosks. We let them come in where they are assisted. So they don't all have to function externally, digitally, but they can come in and also be eased into something digitally with some assistance. So that is our approach to that.
So there's a question from Christie-Anne, because we're kind of in the same space. What has it been like managing the change process so far? That's kind of just slides to end up what you said.
Yeah, a commentary on those things you had mentioned. I like that shift of focus with people as your customers, and I'm sure that is easier said than done. So
I'll be honest with you. I often point out that prior to my move to introducing computer-aided transcription in the judiciary, my hair was completely black. And computer-aided transcription grayed me. Change management in a judiciary is hard. Change management in a legal environment is hard. And you have to understand why that is. It is because the law is grounded in history and tradition. We deal with precedent. We deal with history. And therefore, modern thinking is an enigma. So what I found though, is that as the years have gone on, the change management has become far easier. I think once we got through those couple of big changes, and those big changes were computer-aided transcription, which, believe it or not, people resisted, including lawyers resisted, although they would have been getting their notes of evidence in 2 days instead of in 2 years. They resisted. And for the same sort of reason, actually, I think, as the e-signatures, because somehow, you know, if it's coming like this, then something's wrong with it. There has to be something wrong with it. And that's a place from which they began. And I've come to this stage where, you know, I see lawyers calling for more court reporters, more CAT reporters.
Please.
And every time I see it, I just shake my head. Aside from that, the other thing, of course, was case management, was our first case management information system. That was also a biggie. I'll tell you an interesting little story by the way, with the introduction of computer-aided transcription. We worked very closely with a particular judge and asked him to test out a lot of things. And what was interesting was that the posture of a judge on the bench, because of the fact that the judge was writing everything longhand, the posture was a leaned over posture, yeah, in writing mode. And so we've had the screen up, and so, you know, the notes are coming up on his screen real time, and you initially saw him sort of, you know, glance at the screen every so often, and the posture straightened a bit. The day that he sat up straight and put down his pen, I said, yes, that was it. And that was the transition. And lo and behold, when you look at judges now, the posture is not a cramped over person using a pen. It is an upright person who is listening. They and doing things on their computer as they go along, but the posture is different. And that actually has another side thing to it, in that witnesses also feel that they are being listened to. And that was one of the things that they told us. So, you know, so when it comes to change, there's several things. So as I said, computer-aided transcription, case management, information systems, right? I would say were the two things that really sort of pushed us in particular directions. And of course, giving judges laptops. That was a biggie as well. Trinidad and Tobago was a lot more chauvinistic in the late 1980s, early 1990s, a lot more chauvinistic. You would be surprised. Right. So I do recall a judge, as we gave him his laptop, looking at me and saying, "I don't wear skirts," which was a very interesting comment, but you understand it. Right? Because a keyboard is for somebody who wears a skirt.
Interesting. Interesting.
Let me ask one more question. One more. Change direction a little bit. Some of the things that you've done, some of the software that you've developed in the judiciary is homegrown, like TT Jim. And if we start thinking about different ways to present evidence, do you think the judiciary and the court system can enable the content creation in industry in Trinidad and Tobago? Because if we're talking that people can do animation, their jobs there. So how do you think, how large an effect do you think that would have on the economy if the judiciary became truly an e-judiciary?
Well, actually quite large. Some years ago, I actually started to try to reach out to animators to ask them to try their hand at it. And a couple did try, but I'm not sure that they actually saw, the potential and the possible future in it. I hope now that they're closer to that, because let's face it, if I'm a digital animator and I can create or recreate, let's say, a vehicular accident, by taking the speed that this car was moving and where the car started and where it ended and where the other car started and ended, and I could animate that. Number one, you have taken a whole lot of time away from the judicial ear. They don't need to hear this in long, rambling, viva voce evidence. Number two, they can see it and it is far clearer. Number three, because it is clearer, hopefully insurance companies will fight less. Because when things are presented like that, then you can ask the question, or they really want to come to court, which is an important question to ask. You see, one of the things we have to remember, everybody talks about backlog. One of the things that we have to remember is that there's absolutely no way that we can try all of the cases that come to us.
Correct.
And so therefore, we have to deal with alternative ways of handling people's disputes. And that is one of them. So the role for creative industries like animators is huge. You can just imagine all of the lawyers and all the insurance companies coming to you for animations, for digital animations. Is that not a wonderful big industry?
Indeed,
indeed. And it's not only accidents. When you think about crimes, he ran here, this one shot from this position. I mean, it's at this stage now, it's a no-brainer.
Right, and that's exactly the question that Sean Rock, good evening, Sean, that he was asking early on about that opportunity for the creative industry to become involved. And I think compared to previous times, I think it's a bit more apparent in terms of what the requirements of the court are and how this plays out in a court administrative scenario. Wanted to move along to another.
Niran also commented that if you've revisited with the animators, they would be a lot more interested this time.
This time, correct. Very much indeed.
Maybe talk to Camille at UTT and see whether there's the ability to do something like that, maybe even in some sort of certificate course.
Yeah.
And then you'd put the bar and the animators together and,
and let it take off.
See what can be done.
We actually had Camille Selvon Abrams here on this, well, not on this show, but in an ISOC TT forum last year. So it'll be interesting to connect people and see what happens from there, to let these synergies flow from that point. I wanted to move on to the whole issue of digital transformation and the possible impact it could have on the current backlog of cases. So it's no secret that there is a backlog of cases within the court system. How do you anticipate digital transformation? What is happening right now with case management and the like? How do you anticipate that the digital component affecting the backlog? In what ways specifically?
And don't forget the virtual courts, because that
Yes.
is very important, because you can build a virtual courtroom very quickly, but not necessarily a physical courtroom. So
Exactly so. Exactly so.
That is correct.
all these things going to work together to clear this backlog, get all these people out of remand and properly sorted.
Well, there's backlog in criminal, which has one set of reasons. Backlog in civil, which has another set of reasons. Backlog in, pardon me?
Family court.
and children.
They're good.
Your backlog.
Family and children don't have much of a backlog. Well, children have no backlog. Family matters there's some backlog that is really, at this point, I think just a resource issue, because I think the processes and the procedures are good. The probably more getting people towards mediating. So increasing, further still, the use of mediation. But something you always have to bear in mind in family matters, I want to point this out to you, and that is that they're highly charged emotionally. And whereas with criminal matters and with civil matters, we can be more focused on efficiency only. In family matters, you also have to bear in mind that emotional issue. And you don't want to turn something into, something that is escalate something. So you have to give it a particular kind of air. But when it comes to civil matters, first of all, when it comes to any type of matters, the first thing that you have to do is that you have to relieve the dependence on the judicial air. So what we need to do is to ensure, first of all, that fewer matters actually come to court. So therefore, you need methodologies to deal with that. They are different in civil to they are in criminal. In civil, for example, as I pointed out to you just now with the animation and the type of evidence that you can put forward, people tend not to come when they realize that they have little chance of winning, and they're going to spend money and lose and have to pay the cost of the other side. In criminal, there's that stage of investigation and evidence gathering that is not within the bailiwick of the judiciary. And so therefore, the question of scientific evidence and as well digital evidence comes very important when you come to evidence gathering. If you are seeking, for example, you're looking at plea bargaining, and you tell someone, well, I have an eyewitness who saw you, right? And therefore, I think you should cop a plea. You've just done two things. You have just told him he has a good chance of breaking down a witness, or secondly, you might just have put the witness' life in danger. Those are the two things you've done. If you say to him that I have your DNA here, I have CCTV watching you here and there, and I have looked at the time between here and there and calculated that you would have had to have done X, Y, and Z, or you would have stopped in between or whatever, then he's presented with something that is more irrefutable and is far likelier to recognize, okay, look, let me cop a plea. Now, plea bargaining in the criminal arena is key because, as I said, there is absolutely no way that you can try every case that comes. Also, along the way, there are several other intermediary tools. So when we talk about limiting the use of the judicial air, it's either not having cases which don't need to come to the judicial air, not having them come at all. Or secondly, even in those cases which must come to the judicial air, reducing the number of issues, only dealing with what really needs adjudication. And this too is where our systems and our methods and our case management information and our monitoring, because remember what case management information systems do is that they also help us to monitor and manage. So we can tell how much time a judge has. We can weight matters. We're building that weighting further. We can determine, how long it is going to take for someone to get their matter heard in light of the workload, the throughput, the time to completion, et cetera, et cetera. So all of those things. So you have the sort of front-end user things, and then you have the management elements and the monitoring and management elements within our systems.
Okay, right. We have come to a very interesting point.
Kevon,
yes.
Just one. Chris Chinapu had also asked about the use of AI, because you've been talking about management of information. And AI is something that really can help in managing that information, finding connections in that information, and so on. Do we have any, does the Judiciary Trinidad do we have any plans to start using artificial intelligence, or are we already using it to start?
We're not really already using it, but have we been talking about it? Yes. Have judiciaries worldwide been talking about it? It's the buzz topic amongst all our brother judiciaries worldwide. It's the thing we're talking about the most. And we're talking about where is it appropriate and where is it inappropriate. So for example, you have certain US courts that have been talking about AI in sentencing. You find that the common law courts, the Commonwealth courts are less comfortable with AI in sentencing. So, so there's several things. It's the big discussion. At some point, quite soon, I think we'll start seeing things emerging out of those discussions, and we'll start to see where minds meet. I think our first foray is actually going to be in building our weighting systems and weighting cases. At present, we just weight by case type, but as we delve a little further, we're going to get more information as to how cases actually do process from the use of AI and machine learning. So yeah, that's where judiciaries are with it.
Cool. Let me hand over to Kevon. Sorry I interrupted the last time, but I really wanted to get that AI in.
No, I think AI is very topical for a number of reasons, and it will really be a game changer for what we want to see in terms of progress within the court system. So I'm glad that it's being discussed, at least at multiple levels. And of course, we will eventually have our own reasoning and domestication, appropriation, creolization of AI within our system. So we have come to a very interesting point. We are at the hour that we said we will end. However, I'd like to crave everyone's indulgence to just give us about 5 more minutes I think there's just one last topic or one last question I'd like to ask, which deals with your involvement with something called the Judicial Education Institute, and really that potential for there to be capacity building in court management locally and within the region. Could you tell us a bit more about that capacity building, Judicial Education Institute?
Yes, Trinidad and Tobago Judicial Education Institute is actually, and I make no bones about saying it, the foremost judicial education institute in the Caribbean region. All of the other judiciaries do have either judicial education institutes or some form of judicial education body. But ours is headed by a board, and the board comprises, well, the Chief Justice is the president, and the chairman or present chairman of the board is Justice Gillian Lucky. There are on the board judges, masters, other judicial officers, court administrators, etc. And what the board does is that it addresses the question of judicial education. So judicial education has been a continuum in Trinidad and Tobago since 1996. That is when we started with a Judicial Education Committee, and in I think 2001, we actually turned it into an institute with a board. We are going to be going far more into e-learning. We take into account the fact that even at present, when we hold training sessions for the Judiciary of Trinidad and Tobago, we invite, especially now that we can do it virtually, we invite our colleagues from the other countries in the region. And hopefully what will be happening quite soon, let us keep our fingers crossed, toes crossed, everything, but nothing double crossed on this, is that we should be seeing an e-learning platform that the Judicial Education Institute of Trinidad and Tobago will be hosting and responsible for, and will be sharing with our colleagues in the region. Now, that is a huge sea change, because of course, by moving away from in-person learning and now plain virtual learning to e-learning, it just opens up the opportunities greatly. And it also enables greater use of things like electronic bench books and just continuous judicial education for judicial officers. Some of the things too we've also been talking about is, in common law countries, they actually have judge school. Mm-hmm. And because judicial roles are very different to lawyers' roles, and the skill set is different and the craft is different, we feel that it's important to basically open a judge school for people who are interested in judicial office and interested in applying for judicial office. So that's one of the things that is being discussed. And, with e-learning, that gives us that kind of opportunity. So it's something we're really excited about, and we've started into. We're working with our colleagues at the National Center for State Courts in the US, and hopefully we will be getting good support on this.
Wonderful, wonderful. Thank you so much, Master Morris-Alleyne. We are at that point of wrapping up. Before we do, for those of us following us on other streams besides Microsoft Teams, I'm going to recognize two comments that came up on the whole question of AI. So Niran was saying that with AI, you have issues and topics of implicit bias being coded into systems, and then what you do is such bias is discovered and to remedy. So I believe that's an ongoing concern with the AI discussions, the ethics and the biases that could be coded within and how you safeguard against those things. Dion Santana says that application of machine learning with judiciary matters is an extremely complex and risky thing due to issues of bias coding, but even more concerning accuracy, one wants to be very careful about which processes you apply machine learning in and in which way it is applied. So it's indeed a science, and it needs to have specific consideration before being applied here in the region. Nonetheless, we do recognize that it has a huge potential for changing the entire landscape of how fast and how efficient court matters are processed within this country. I don't believe we have any other matters of the content to address at this point in time. Jackie, am I correct?
I'm just gonna say, if anyone has any question, this is your last chance. One question, counting down, hands up, or in the chat.
More indulgence to ask those very final questions.
4, 3, 2, 1. No questions. Okay, well, thank you very, very much, Master Morris-Alleyne. You have been a font of wisdom and history and vision. And honestly, I would absolutely look forward to being a customer of the judiciary in the maybe 5 years.
You're going to bring a matter, Jackie?
It depends on which way.
I can go through the whole thing in my house very comfortably. I don't have to hire a lawyer to probate any will. It sounds like it's like a self-service judiciary coming up here.
Yeah.
Or if you
don't frighten my legal colleagues. Not quite. You definitely need the lawyers to do quite a few things.
Right.
So
okay.
I love the mention of the small courts and civil matters under the 50,000. I love to be able to navigate that. I consider myself a pseudo lawyer. I have legal training, but I'm not a lawyer. But I found all of the points truly enriching, truly enlightening, and I have learned a lot in terms of what our judiciary and what our court system is like, and the infusion of technology along the points. That trajectory from computerization, that word just struck a note in my head, chord. And I knew it was from the 80s.
This afternoon, you will.
But it's good to see that those various steps and those various culminating points that have happened, and it seems to be very promising to seeing a real e-justice experience coming for all. And the point that Jackie was making about the digital divide, that is very relevant, that when we talk about justice and we talk about digital divide, we really want to ensure that everyone under the sun has access to justice in some form or the other. So I thank you so much for tonight's conversations with. I am truly grateful for all of the information that was displayed. I think that our attendees were also grateful for that information. And I will just hand over again to Jackie to give us those final announcements and possible trailers for upcoming sessions.
This was our 5th in the webinar series. Next week, we will be having Kevon. You know the name.
Mr. Rishi Maraj.
From?
Mr. Rishi Maraj, who was of the Equinox Institute. He is a data protection privacy consultant extraordinaire, probably one of the persons who has gotten all of your privacy assessment qualifications possible in this country, with humble beginnings within the Office Responsibility for Data Protection. There is no Office of the Data Protection Commissioner. Data Commissioner, right? I'm saying that he had responsibility back then, and this has evolved over many years. What he has seen in terms of the possibility for the Caribbean and Trinidad and Tobago in particular to position itself as a strategic player when it comes to data processing activities, simply because we are poised and we are appropriately situated between the big data concepts, the two poles, which are what happens within the European Union and what happens within the US. So Rishi is carded to be our speaker next week.
Next week, Thursday, starting at 7 o'clock. And same place, same time, new day, 7 days away next week.
Correct.
So we look forward to seeing many of you here next week. And thank you very, very much for your attendance. I hope it was great. I hope you learned. I hope you enjoyed it as much as we did. Thank you very much. Bye-bye.
Bye-bye. Thank you. Thank you, Kevon. Thank you, Jacqueline.